Hi, everybody. Welcome to today's YouTube Live. Today, you've got Carrie and me. And look, we're in the same space. So this is awesome. We're very excited to get into it and help you guys get through all the questions you have. Without further ado, you ready?
I'm ready.
Let's do it.
You want to go first?
I'll go first. Okay.
All right.
SkyPod images.
We should have flipped the coin.
We should have, yeah. Generally speaking, do Gulf War illness claims, brain fog, cognitive decline, memory issues, and presumptive take longer and are harder to prove for approval? Thank you. I heard the VA makes you jump through hoops to get Gulf War illness claims approved. I don't know that it's harder if the evidence is there, but it is harder because VA has a really hard time understanding what those rules are and how to do them. Carrie is the Gulf War expert, so I'm going to let him jump in on that one.
Well, I think the answer is yes and no. No, they don't take any longer than your typical claim. In my opinion, yes, they are harder if they are not express presumptions like chronic fatigue syndrome, irritable bowel syndrome, fibromyalgia. If you're going for something other than that, then it's going to come down most of the time to whether it's a medically unexplained chronic multi-symptom illness. That sounds like a mouthful, and it is. It's defined as a diagnosed condition of unknown pathophysiology or etiology. So that's a little different than a straight up undiagnosed illness. All right. That is an actual diagnosed condition. VA may tell you otherwise, but you can have a diagnosis for it. It's a case by case basis. And it's what you're usually going to look for is there an etiology for that condition for your specific case? And if the answer is no, then you can win those. But finding people that understand Gulf War claims really good is really difficult. I can probably think of about 5 in the country that do. 2 of them are sitting in front of you at the moment. Now, there may be others that say they do, but most people don't. They are complicated. And unfortunately, PACTAC's made a good bit of headway on that. But pure Gulf War claims under the 1991 rules, yeah, those are difficult.
If you are dealing with those, I always recommend getting an advocate because they can be extremely complicated.
I like them though.
He does like them. Let's get at him.
All right. Isidore Vasquez. I have 20% cervical strain arthritis, and I've been having pain on the right side of my neck, going down my shoulder and arm. I have a referral to have this looked at if the diagnosis is radiculopathy, which may be the case according to my research. What could be the percentage for a secondary? So it does sound like radiculopathy. I have a triple fusion in my cervical spine, and I'm well versed in upper extremity radiculopathy. I'm sorry, there's more to this. Okay, hang on. I have 20% for type 2 diabetes, and I'm now having issues with my feet, tingling, and sharp pain. I have a referral to check for neuropathy. According to research, these are symptoms percentage. These are the symptoms percentage. Okay, more. I'm having pain in my right thumb down along the wrist. I injured my right hand on active duty and documented it on my active duty military record, not knowing the diagnosis yet, but having service connected. Would this be a good claim to submit? Okay. All right. So let me back up what I was saying. You've got a few things going on there. You've got service-connected cervical spine and service-connected diabetes. Yes, the pain you're feeling could be could be a radiculopathy from the cervical spine disease. It could also be a peripheral neuropathy from the diabetes. They both feel very similar, but since both your diabetes and your cervical spine are service connected, if you're not service connected for the extremity, the upper extremity, then yes, unless you're 100% already, I'd file a claim for that. Percentage wise, I mean, we can't say what the percentage would be. It depends on the severity of the pain. It could be 10%, it could be 30%. Most of the time they average 10 to 30. Could be worse if you had loss of use. The thumb, I could see that being rated separately, but I could also see it rated along with the entire radiculopathy because it could go down into your fingers. So that's that would be the best I'd have on that. You got anything, Ursula?
So I would say if you've got the diabetes and neuropathy and you have the cervical strain with the radiculopathy, I would file for both because they are different. The radiculopathy kind of comes from this part out, whereas the neuropathy comes from the fingertips down, and you're rated based on the nerves that are affected. So if the radiculopathy is so bad that affects all the nerves down to your fingers, you're only going to get a rating once for that. But I would go ahead and file for the neuropathy and the radiculopathy. As far as for your wrist, like he said, I think it just depends. You can file for it. If it can get service connected, you could see what happens. But, keep in mind, if there's an overlap in those conditions, you're not going to get rated for both of them if the symptoms are the same. Rodney Oldham. Okay. If a married couple are both 100% permanent and total and one owes a VA debt and the other doesn't, will VA garnish both of their funds until the debt is paid off? I don't know.
So
Don't know.
Let me read this again. If a married couple are both 100% and one owes VA debt and the other doesn't, will VA garnish? No, VA will not garnish both of your funds. The debt is to the veteran that owes it, period. And so I'll take that a little further, not to be morbid here, but let's say you're both 100%, one of you owes a debt, and let's say that person passes away. All right, they cannot put that debt on the other person because it was that other particular veteran's debt.
I have seen them try to charge the estate, though.
I've seen them do that as well. That's not, that's a little more rare, but they could try to get you that way. But no, they're not gonna make both of you pay the debt. So I've never seen it in 27 years. So I would highly doubt that. All right. JDH 18702 are migraine auroras with severe vertigo, but without headaches, VA rated. Vestibular migraines. So, I mean, they're going to rate migraines. There's one diagnostic code for migraines, and it's rated mostly on prostrating attacks, which means attacks that are completely debilitating. Usually that's the pain that comes along with migraines. So, it's going to come out to how the examiner explains that on a disability benefits questionnaire. If the auroras and vertigo are prostrating or are incapacitating somehow, that's possible. But, normally I would say a lower rating without the actual pain that comes along with your typical migraine.
Yep. Does receiving a penile implant cancel ED as a secondary to mental health meds rating? I have never come across that, and I don't know. I feel like it would.
It's not supposed to.
It's not supposed to.
If you already have the SMCK for erectile dysfunction for loss of use of a creative organ, and you are able to overcome that with something in the future like an implant, they're not supposed to come take that K away. That doesn't mean they
would try. They would probably try. But yeah, try to get it back.
Constitutional.
Do you want me to read it for you?
No, I got it.
You sure?
I'm just a little old with my glasses. All right, so I don't have my normal gigantic screen here. I could probably read it without them, but a little easier. Constitutional immunity 2.0. I'm not sure what that means. So, good day. I'm 90% for SC back for numerous issues stemming from back injury. Will I mess up my 90% if I go after secondary issues like depression, migraines, IBS, erectile dysfunction? You should not, as long as the conditions you're claiming are secondary to the back and you're not claiming an increase in the back or an increase in any of the residuals that you currently get service-connected for the back. They should only examine the secondary issues. Now, that's not to say it can't happen, but it should not happen. If they set you up for a back exam as part of a claim like that, and you weren't claiming an increase for a back exam, I probably wouldn't go to the exam, simply because that's not part of the claim. But just make sure, however you word it, that it can't be interpreted that you're claiming an increase in the already service-connected disability.
You may see them order the exam though, just because those first line raters will just be like, "Oh, they said back, or we're going to order an exam and everything."
Yeah.
So good luck. But I would definitely, if you have those issues like depression and migraines, I would file for them if they are secondary.
Yeah, because at 90%, that could easily go up to 100 with enough residuals there.
Mm-hmm. Is it me? Yeah.
Is it you?
Okay. Kent Griever files sleep apnea secondary to rhinitis. CMP examiner denied direct service connection with accompanying rationale. No entries in secondary section of DBQ. Okay. Is there more, or is that it? Okay, so you filed for secondary and VA only asked about direct service connection. I'm assuming that you're asking kind of what you should do if you get the denial. Is that what you're picking up?
That's what I'm picking up.
That's what you're picking up. Okay. So they have to address all of the theories that you put forward. So once you get that rating decision, if it's coming, I'm assuming it's coming from a supplemental claim, just file a higher level review, let them know I said secondary and that wasn't looked at. The higher level review would probably punt that down for additional exams, asking the correct questions. But they do have to make a decision on that.
Yeah, and understand expected denial on that. These examiners in today's VA are hardly ever going to give you a favorable opinion on anything doing with obstructive sleep apnea.
We get on every single client literally the exact same rationale, no matter what we've asserted, what we've said. And it's like amazing that all these vets who live all over the world all have the exact same rationale. It's a canned response, and you're probably going to have to fight a little harder to get the sleep apnea. Happiness.
All right. Hubby, now at 190%, sent another 22-10210 to Caregiver program, fighting since 2021. I wonder if they back pay for that and helpless child never lapsed. Yes, any Carol's Corners with a helpless and caregiver. Also would love for fellow veterans to know about IED blasts, TBIs, and central sleep apnea.
I can take the first part if you want to take the second part.
Go for it.
Benji, can you go back to the first part? Okay, so the caregiver program. I am all over the caregiver program right now.
She's the boat of Zephyr.
Learning so much and doing so much with it. So if you had a denial from the caregiver program and you are trying to appeal it, you can do that. So a 10210, that's just a statement form, isn't it?
I thought so, yeah.
Did you file a 10182 or a 10210? Okay, I'm assuming, well, you said it's that form, so that's the statement form. What you need to do with those is file an actual appeal. You can file an 0995 with the statement with that 10210. But what I'm finding is that they're really not going anywhere. They don't really know where to put those. And we're not really seeing decisions from them. But you can go to the board into the evidence lane with that 10210. If it's an issue of entitlement to the program, like whether or not you should get benefits, most of the time those are getting remanded. But if it's just about the stipend, I have seen the board grant those. But what they should be doing is once it gets from the board down back to the caregiver program, it should be that effective date of 2021 if you've continuously kind of kept it on appeal. I've seen issues where, there's a lapse in appeal, people are filing again, and it's just kind of all over the place. So I think just try to get the benefit and then work on the effective date. And for helpless child, that's a different issue. That's filing with the 686C and saying that you have a helpless child. The biggest thing with the helpless child is you have to prove that before that child turned 18 years old, that they were unable to sustain in the community, meaning they're unable to work and will essentially never work, but it has to be prior to the time they were 18. So if you can prove that either through medical records or something like that, you should be paid back to that. The helpless child is also a little different because it's based on your claims, just like a dependency claim is. So if you've been filing and you've been eligible for these benefits for your helpless child, it should go back from the time that you became eligible once you had the appeal in. Is that a lot? That was a lot. Okay, no. Okay, go ahead.
All right, what's the second part? Would love for fellow veterans to know about IED blast, TBIs, and central sleep apnea. So I'm assuming that you were asking about the relationship possibly between central sleep apnea and TBIs resulting from IED blast. Now, I can't tell you that from a medical expert perspective because I'm not a medical expert. Central sleep apnea is a little different than obstructive sleep apnea. You don't see as many cases of central sleep apnea. In fact, I would venture to say you may very well get a diagnosis of obstructive when it might actually be central. Central is a little bit neurological. It's not just upper airway stuff. It's definitely relatable in some cases to TBIs, whether it's from an IED blast or some other kind of TBI. But I would, if you've got sleep apnea, I would make sure that is it obstructive or is it central? It should say that in the test results if they've given you all the tests for sleep apnea. If it turns out to be central, and you've got TBIs, that's one avenue to approach there. You can also have a mixed variation where it's a bit of central and a bit obstructive. I would do the same thing there, but if you've also got things that could affect the obstructive point, then go after that as well. I think you're still going to get the same CAN response since we're talking about sleep apnea. You may not get it as much if the examiners are aware that one, it is central, not obstructive, and two, that you've got some conditions that may that may cause the central versus the obstructive. I don't know if that's what you were looking for, but off the cuff, that's about the best I can probably give you without doing a little bit more research myself. All right, my turn. Okay. Alan Glover, I am taking the word tomorrow, Thursday.
Benji, can we go to the next one?
And I know.
Skip that one. There you
Okay. I was awarded 70% for PTSD in 2024, filed for an increase and awarded 100% in 2025. Also filed for TDIU. They deferred it a few weeks later, awarded it in 2025. I'm 100% PNT. How does TDIU affect it? Well, it doesn't.
Yes, it does. She can get TDIU back to 2024.
Right. Well, that's the effective date. So if you're all right, so let's break this down into two parts. She's right and I'm right. All right. Let's if you're talking about how does the TDIU affect the 100% rating? Well, it's half a dozen of one, 6 of the other. At the same time, she's right. If you got 70% in 2024, as long as you weren't working at that point in time, you filed your TDIU claim as part of the appeal or as part of the original claim, as long as it's within a year, then that TDIU should go to the 2024 date. What you will see VA do lots of times is once you're at 100% scheduler, they'll say, well, TDIU is moot point. It's moot because you can't get more. You can't get TDIU since you're already at 100% scheduler. But they're almost always wrong if you've had a claim going back longer than you've had the scheduler 100%. That means TDIU is not moot. You could get TDIU for the period prior to the scheduler 100% rating. And so if that's what they've done here, and it sounds like probably so, since it sounds like you did the increase within a year there of the 70%. I would make sure that they give you TDIU back to the point that you got 70% if they haven't, or if they end up denying it.
Or from the time you last worked. If you last worked in 2025, then you can't go for the TDIU. Okay, second question. Filing SSDI. Should I submit my 100% PNT rating or TDIU rating? I'm under 50, so any advice for SSDI? ? Heard it is harder under 50, still within my 5 years to qualify. So we don't work in the Social Security world. We do see determinations that come from Social Security when we're dealing with our VA clients. They're not supposed to make a decision based on what the other agency did. So I know if Social Security was denied, VA can't deny because Social Security did. And I think it goes the same way. I don't know how to answer that question because I don't do Social Security. So
yeah, I'm about the same.
Yeah.
One can help. I mean, we've seen people use one for the other for years. And it can certainly help in a persuasive manner. But the thing you just have to know that one doesn't bind the other.
Mm-hmm.
A lot of people will try to use Social Security to prove VA benefits, and there's no what's called Social Security rule in VA. In other words, if Social Security finds you unemployable, doesn't mean VA has to, and it's vice versa. But obviously, if you're 100% PNT with VA, that's evidence that Social Security is going to consider. So definitely use it, get it in your record for Social Security.
And that can look like getting your claims file and all the exams and things like that they use to get you to that 100%, like the evidence that was used to get you there. I would put that into your Social Security file, even though they will do their own evaluations.
Yeah. Especially you end up appealing to Social Security. You don't want the Social Security Administrative Law Judge to only have the Social Security evidence in front of them. John Wilson, should I get service connected so if something happens to my wife can get DIC? Well, yes, you should. It doesn't mean that she can't get DIC if you're not service connected. It can be harder depending on the circumstances, not necessarily. The question's kind of vague, so I don't want to get into all of DIC is.
It depends what you're getting service connected for. Like if you're getting service connected for hearing loss, probably not going to help with DIC unless you're
100%.
Yeah, unless you're 100% for so many years. But if you have service conditions that should be service connected, you should be filing anyways.
Yeah.
And then absolutely you want to do what you can to set your wife up for DIC. Sorry,
No, that's okay.
Okay. What does regular mean in terms of ANA? I was given a favorable finding that I require aid and attendance, but denied SMC because of not regular. It is pending in higher level review. I have spinal flare-ups that last up to 3, Carrie's loving this one, months and occur every 6 months. So I'm going to go first and what are stage ratings? So we'll do both of them. First, aid and attendance is SMCL when you require the regular attendance of someone to help you with your activities of daily living or to keep you safe in the community. That's essentially aid and attendance. You need someone else's help. I'm going to pass this over to Carrie because I know he wants to talk to you about what the regular aid and attendance means. Because it's not regular is not constant.
It could be two things. They could be talking about two things.
They could be. Okay. But regular does not mean constant. And a lot of times VA says, well, you don't need it all the time. And that's not part of the requirements. It's just regular. And if you're regularly having flare-ups and you regularly need assistance, I feel like that's aid and attendance. All case specific, obviously. But go ahead.
No, I mean, you answered it pretty much there. So when I hear regular, I think of two things. Like Ursula explained, it's how often you need the aid and attendance. The courts have said very clearly it does not have to be constant. So what does regular mean? Well, there's no defined meaning of regular. It just doesn't have to be constant. So, once a week could be regular, once a day could be regular, once a month could be regular. Depending on, if it's 5 minutes for once a month, that's probably going to not be regular. If it's for weeks at a time, that's different. So if they said you need the aid and attendance, I would look at it like this. You've got what's probably a first line rater saying it's not regular. Well, I would appeal that on the merits alone, okay? Because the first line rater doesn't get to say what regular is. The other thing I think about when I hear regular aid and attendance is the first level of aid and attendance, as opposed to a higher need for aid and attendance, which is generally what you're talking about when you're getting into the much higher SMC ratings like R1 and R2. So regular ANA in that instance would be the SMCL or ANA at the SMCL rate versus ANA at the R1 or R2 rate. Most people are not going to qualify for the R1 or R2. And you don't want to qualify for that. You're talking loss of use of all 4 extremities, loss of use of 2 extremities with a separate need for ANA, completely separate set of disabilities. I mean, it gets fairly complex at that point. But that's the only thing I would add.
Okay. All right. So stage ratings. Okay. So you really deal with stage ratings when you've got claims that go on for a very, very long time. So let's say you file for, a back injury in 2010, and it goes to the board and the CAVC, and it takes a while. And finally, 10 years later, you're service connected. And they go back, and now your back is really, really bad. But when you first filed, it wasn't that bad. So they come in and they give you a 0% rating from the date you first filed, because that's what the evidence shows. They have to look at, so when they're doing that, instead of just giving you a 0% all the way up to today and then say, okay, you're going to be a 0% to 60%, because we had an exam, 2 weeks before the decision, they're supposed to stage them, meaning that as you go up in severity for that condition, they're supposed to rate you accordingly as the evidence shows. So that's exactly what it is. It's, going from 0 to 100 with stages in between. That's the best way I can describe it. Yep.
Oh, you're right. H. Hill, rated 30% for PTSD. Would it be worth it to attempt anxiety claim to see if it's approved at a higher rating? All right, so you're probably going to get multiple answers on a question like this, and maybe different ones between Ursula and me as well. But here's what I would say. In the strict context of your question, no. Okay, that would be my short answer. And that's because you're not going to be rated for the PTSD under one set of criteria and the anxiety under a different set of criteria. Those are both mental health disabilities. They're going to be rated under one code if they service connect both things. Okay, and understand that PTSD is an anxiety disorder. Okay, so it would simply read on the code sheet or the rating decision, service connection for PTSD with anxiety is granted. It's still going to be rated based on the overall severity of the mental health condition. And so should you attempt to claim anxiety? The reason you got just as much of a chance of getting an increase by claiming an increase in the PTSD. If they were to come back and say, well, there's PTSD here and it's only rateable at 30%, but there's also anxiety here and it's rateable at 50%, but it's not service connected, right? And they keep you at 30, then that's a very valid appeal, because I guarantee they've misapplied some very important case law in there, because the only way that could happen is if they decide one or the other is not overlapping, which is impossible to do when you're talking about PTSD and anxiety, since PTSD is an anxiety disorder. Now, there's a possibility of them being able to do that if it were PTSD being the service-connected condition and, say, schizophrenia being the non-service connected condition. But even then, it gets very difficult to separate out the effects of those two things. And if they can't separate the effects, there's a case called Mitlider that says they must attribute the entire picture to the service-connected condition. So in my opinion, I think you got just as much chance of getting an increased rating simply by filing for an increased rating. With 30%, I mean, the likelihood of them reducing that is very low. And if the overall mental health picture warrants more than 30, then that's what I would go for.
That's what I would do too. So we do agree on that. We agree on that. That's what I would do.
See, we don't disagree.
We don't disagree. Okay, Michelle McNeil. The VBA is granting 0% for removal of right ovary with tubo-ovarian for the left ovary. Already have 30% for removal of uterus. The left ovary was left to avoid premature menopause, but still have to go on estrogen therapy. Shouldn't they grant 30% for both ovaries with loss of use of the left based on, this was added February 2019. This is a BVA remand from a claim filed July 2018, and the BVA continued at 0%. I would have to look at the ratings for that. The uterus being gone would be usually a 0% with an SMC attached to it. I would have to look that up. Do you know?
Go back to the first part. BBA is granting 0% removal right over tube ovarian and 30% for. Yeah, so against popular belief, we don't have the entire rating schedule memorized.
Yeah.
Most of it, okay. So it comes down to this, I think. You've got a different rating for complete hysterectomy with bilateral oophorectomy, if I'm saying that right, meaning a removal of both ovaries and the uterus. That does get a higher rating than just removal of the uterus. You've got another code that's just for the ovaries and another one just for the uterus. I would have to look myself to see if it actually requires removal of both ovaries or if it's rated the same if one of them can be non-functioning. Here's what I would look for without opening the book. All right, the ovaries, since you've got two, just like you got two lungs, two kidneys, two hands, 2 feet, there's a code. I want to say it's 3.816. I might very well be wrong on that, but it's the paired extremities and paired organs code. And what that specific regulation says is if you've got loss of use of one that's service connected and loss of use of the other that's non-service connected, they have to compensate you as if both were service connected. So if you have an amputated right hand from a blast injury in the service, and it's obviously service connected, and an amputated left hand because of a non-service related car accident, then they have to compensate you as if you had loss of use of bilateral hands, both due to service connected. I would look to see if that same rule applies to the ovaries in the context, do they have to be physically removed, or can one still be present in simply non-functioning, meaning loss of use? And if that's the case, then I would argue for both ovaries plus the uterus, which would warrant the higher rating. If the rating schedule doesn't speak to it expressly, and I don't remember off the top of my head if it does or not. If it, and you can look this up in Title 38, the codes for the ovaries. If it doesn't require removal, or if it doesn't specify one way or the other, well, then I would argue it anyway, and take it. You probably have to take it to the Board of Veterans Appeals, because they'd have to, in my opinion, they would have to veer on the side of the most favorable to you, which would be the loss of use. I hope that makes some bit of sense.
I am going to go read it after this just so that I know, because that was a very good question. Thank you.
Sherman Barker.
I'll read it. Let me just read it for you. Let me
Okay.
just read it.
I can read it.
I'm going to read it. Okay. I'm at 100%, but not permanent in total. All my rated conditions are static. How come I'm not permanent in total? And what do I do to get there?
Do you want to answer that? You want me to answer?
You go ahead. Because the answer I'm going to give is.
Go ahead, give your answer.
It's very difficult. It's not difficult, because if listed as static, that means that they're not expecting it to get any better. So you could write a letter, write a memo, be like, hey, I'm permanent and total. I haven't had the most success with that for some reason. And it's difficult. One way to do it is go for IU, get IU granted, and then it's permanent and total usually. I don't know. Like, there's no good way to do that. Do you have a good way to do that?
Good.
Or one that you've seen work?
No particular way. No.
Mm-hmm.
Look, here's the thing, and there's a lot about this question we don't know. If you're 100% for multiple musculoskeletal conditions and you're 30 years old, they're probably not going to rate you permanent. Okay. And in a situation like that, sometimes the best thing you can do is simply let it ride until they bring you in for the review exam and ensure that it hasn't improved in the review exam. They're eventually going to make it permanent. Okay. If it now on the rare occasion that it's something that's static and they should have made permanent, they just didn't. It could be a situation where they just left it off by accident. So it really depends on the situation, and that individual vet. While there's no rule about age specifically, obviously the older you are, when it comes to certain conditions, it's pretty much accepted that they're not going to improve. So that could help. If you're an older veteran there, Mr. Barker, and you had these conditions at the same level for a while and they're only getting worse, you may be perfectly safe in asking for them to consider it permanent. But that very well might mean they're going to bring you in for a review examination, which they're going to do anyway eventually. And they're eventually going to make it permanent as long as it's not improved. So it kind of comes down to, do you need, what do you stand to benefit from the permanency? I realize there's ancillary benefits, Champ VA healthcare and stuff like that. Is that something you're going to use? Because if you're not, if it's just wanting to be permanent on paper, sometimes it's just let it ride and they're going to bring you in for the exams. They're going to see that you've been rated 100% for a while. It's going to make it immediately harder for them to reduce it the longer it's been that way. And so sometimes it's a situation where you don't poke it, but don't poke the bear. Other times you would. It just depends on your specific circumstances. All right,
Alan Glover. It's my turn.
Oh, it's your turn.
It's my turn.
He's
trying to steal my turn. Alan Glover. I received TDIU, permanent total headaches, ulcers. I'm putting in for diabetes and hypertension and sleep apnea, who's denied when I went to the board in 2022. My hearing is Thursday. What can I get out of it? They would pay me to 2022. Go back, Benji. I'm going to be honest. I'm not entirely sure what this question is asking me. You're permanent and total with headaches and ulcers. You want to file for diabetes and hypertension and sleep apnea. Refile for them because they were denied in 2022. So I'm assuming you'd have to file an 0995 to that. But if you're already permanent and total with TDIU, really think about what benefit you would get for the diabetes, the hypertension, and the sleep apnea. Sometimes it may just be better just to leave things as they are, especially if you are permanent and total. You may not get any additional benefits by service connecting these issues. What you got? Help me.
I kind of have to be the same on that one, unless you're wanting to schedule 100% and want to go back to work or something. If you know you're not going back to work, Just adding diabetes and hypertension to some multiple conditions that's causing unemployability. You're not going to get extra benefits. It's not going to take you to an SMC rate or anything. So,
I mean, sometimes I'll file for like the diabetes and the hypertension if it's setting up for DIC or something like that, but not when you're already 100% permanent and total. And, if it's setting up for DIC and something happens to your wife comes in, she or your husband, they can assert the diabetes and the hypertension to get that service connected to get you there. So really think about what your purpose is. If it's just to get those service connected, I don't know that I would do all that.
I mean, if your diabetes is so bad you lost both feet, you would stand to gain then. But if it's diabetes is just getting treated with medicine, otherwise fine, you're probably going to get 20% out of it. Hypertension, most you're going to get there is 10%. Sleep apnea, you could get 50. But even the combination of those things, if you're unless you're permanent total through TDIU for one condition, that could get you to SMCS at that point. But if it's multiple conditions, even adding all those to the ratings, it's not going to get you above 100.
Yeah, I think it's a couple because he says headaches and ulcers.
Yeah, sounds like it.
All right.
Okay.
I'll read it for you.
No, I get to read.
Ooh, what's going on with the BVA backlog? That's what John Johnson wants to know.
Yeah.
What's going on with the BVA backlog?
Well, my crystal ball is broken.
I don't think that's looking into the future. I think what's going on with the backlog is things we don't know. We don't know. The backlog is still there. There's nothing going on with it. Like they're making moves.
That's kind of the board has not been very forthcoming in the past couple of years as to what's going on. We've seen some positive signs when it comes to, say, direct AMA appeals. A little while ago, they were roughly at 3 years. Now they're roughly at 1 year. But that's a small subset of the total appeals at the board. Legacy appeals, which there's still quite a few of. No one knows what's going on with those things. The ones that get advanced on the docket, like if you're over 75 or homeless or terminally ill, those still go at a pretty decent clip, usually 1 to 4 months, give or take. But as far as because they're sliced into various dockets now, it's harder to put a finger on the whole backlog. When everything was under legacy, everything had to be done in docket order, and you always had the same docket number staying with that legacy case. It was a little bit easier to gauge the backlog at that point. But now you've got different stovepipes, and some are fuller than the others.
I have an idea, though. I just thought of something. So one thing it might be is not necessarily a backlog, but there was recently a case that came out that said that the board isn't allowed to decide an appeal until the timeline to switch dockets has expired. So what that means is, let's say now you get a decision in July, you file an appeal to the board into any of the lanes in August. They cannot make a decision on that claim until at least July of the following year, because they have to allow you the time to switch dockets if you so choose. And so they are having to hold cases just for that. Not that I think they were even getting to those cases within that time. But if you do have something that's pending at the board in any of those dockets, there's something like you need to send in a waiver. You waive your time to switch lanes, and then it'll I think that might move you up a little bit faster. But I mean, I don't think there's ever not going to be a backlog at the board, ever.
I've been doing this 27 years and there's always been a backlog at the board. Don't ask for a hearing, and I mean, unless you really need one. And sometimes there's a good reason for it. But most of the time, whatever you can say in a hearing, you can say in writing. But if you ask for a hearing in today's VA, it's going to take a number of years for that to work its way through the system. And they're not going to decide that case until they give you that hearing. So that's probably my best advice. If you want to ensure your case goes the fastest, do not ask for a hearing. I know VSOs out there are asking for hearings left and right.
Don't do it.
Yeah, I wouldn't do it.
Yeah, for the timing on the hearing, once you ask for that, they have to give you the hearing, schedule it, which is a while out. And the judge that you see is not even the judge that may be ultimately making the decision. So then they have to wait at least 90 days for you to get your evidence in and all of that, because that's what the evidentiary rules allow. And then you're going to go to a different judge who's just going to read that transcript. They're not going to have seen you or have done anything. So to me, the hearing lane, I don't understand really what the benefit is to it, as opposed to just writing an argument.
Navari.
I got it. This is your question, right?
You can read it. I can read it. I'm working on a claim for a vet from 1975, MST verified, but did not pay because she was diagnosed with depression and anxiety and not PTSD. Should I do a supplemental or HLR CMP verified MST stressor? We do see that one quite a bit.
Also worked in kitchen cooking from 73 to 77, used M2 burners and immersion heaters, which put off lots of fumes, used leaded gasoline, and now has toxic exposure conceded. Can I link anemia to this?
The anemia part, I think, is difficult. If it something more progressed like leukemia or, I don't want to say you can't link it, but anemia is going to be rated very low, 0 to 10% maybe. But if it progresses to something else, then it becomes a little bit easier. Not that you want it to progress. The mental health, we see that a lot. With a person will claim PTSD due to MST. They concede the MST, but then they get diagnosed with something other than PTSD, and then the VA comes back and says, well, it's not PTSD. We can't service connect. One thing I would find out is, did they add, let's just, for argument's sake, say you don't have PTSD, but you do have depression and anxiety. Did they even make an opinion on the depression and anxiety as whether it's related to the conceded MST? If they didn't, there's a duty to assist error there, which can be resolved probably with an HLR conference. And usually they don't. You would think they would think that far ahead, but they don't. If they say, no, it's not related, well, now you're going to have to kind of start looking for your own evidence. And that's going to depend on the facts of the case and the kind of resources that you have. So you have more on that?
No, we see it all the time. That is very common. Winnable, fightable. AMA or BVA, which is better? So I think you're a little confused on the AMA. So there's AMA and legacy, which are the appeals processes that we use. They have different rules and different forms and all of that. And then the BVA is the Board of Veterans Appeals. So the AMA covers the regional office and the board. It's the rules that they're going to use, or the legacy rules. If you're asking regional office or the board, which is better, most of the time the board is going to be better. You get people that actually kind of know but it depends. You may be able to get things done with a higher level review depending on what that issue is. So it depends. I know that's a horrible, that's a very lawyer answer, but it does depend.
Yeah, and if you're filing claims now, or anytime past 2019, you are in the AMA, like it or not. There's nothing you can do about it. The only people that are in legacy, the AMA stands for the Appeals Modernization Act, which was passed in 2019. If you had an appeal pending prior to then, it was in the legacy system. It only started being called the legacy system once the AMA came about. Before that, it was just VA system. Okay. If it stayed in legacy and it's still alive today, you never opted into the AMA system, then you may have a legacy appeal. There's less of those, obviously, now that we're 6 years past passage of the AMA. If you file a claim today, you're in the AMA. You can take that claim to the Board of Veterans Appeals. So you're talking apples and oranges there.
All right, we're going to take one more question. Last one.
Angel Morero. I've seen that name before.
We have, yeah.
Greetings. Can you infer a much higher level of SMC if you qualify? Let's see. Greetings. Can you infer Can VA, I'm sorry, why am I saying you? Can VA infer a much higher level of SMC if qualify of that which the vet is applying for?
Yes. The answer to that is yes. If you file, oh, sorry, this was your question.
No, I just got.
You couldn't read it, so I'm just going to answer it.
I lost the ability to read there for a second.
Right. So the answer is yes. If you just say, you file an appeal for a higher level of SMC, VA is supposed to infer the highest level of SMC that you qualify for. So you don't have to specifically go in there and say, I want SMC L or M or, whatever level it is. You can say, I want aid and attendance, which is a specific level. And then they'll be specifically looking for those, what's the word? I'm not qualifications. Oh, what's the word? Okay. Either way, they'll look at those. But if you then have other things that could get you, let's say, to an M or an M.5, they are supposed to go ahead and put that stuff in there. If you go in and you think that, I should be, at R1 and they only give you L, you can appeal that and say, hey, I want a higher level of SMC. And typically that's how I will phrase it, is just higher level of SMC versus asking for a specific type, because you don't necessarily want to bottle yourself into only asking for that level. Sorry. Yep. Is that it?
I think there's something you need to know, though. In today's VA, let's give you an example. A mental health condition, right? Say if you've got a very severe mental health condition that would warrant aid and attendance. That's as severe as it gets for mental health. And they rate you 100% for mental health. And they rate you permanent and total, and they consider the case done. You come back and you say, no, I'm appealing for aid and attendance. You should probably expect them to come back and say, well, you didn't file for aid and attendance. You have to file for that. You didn't file for SMC. And they're going to send you letters and make it look like you have to start a new claim for SMC. That's because they do not understand that this is an inferred issue that they must consider when the facts show that it might be there. Now, they're not going to infer it to deny it, but they should also not force you to file a brand new claim for it. You can appeal for SMC, but just be wary. They might send you a letter saying, no, you have to file a new claim. You don't have to do that. Now, sometimes you may have to do that just to play along with them and argue about the effective date later, simply because of their stupidity. It's a little bit different on each circumstance. If they grant A&A, let's say they inferred A&A and they grant it, and you come in and ask for a higher level of SMC, that's a little bit easier for them to get their head wrapped around, because there is a level of SMC there and you want a higher level of SMC. Or if you're arguing for a loss of use of an extremity for something that's already service connected, that's going to carry SMC as soon as they grant loss of use, if they do. But if you're just going for A&A and out of 100%, I would expect them to come back and say, yeah, you need a new claim for that, when you don't.
No, you don't. All right. Well, that's going to finish us up for today. I want to thank everybody for joining us. It was good to see everybody. Well, we didn't see you guys, but I'm glad you guys got to see us. So we were here for you. It was horrible. All right. We'll see you guys next week. Well, someone will see you next week. Y'all have a wonderful week. Bye.
See you.